Long-Term Care Ombudsman, and welcome to this webinar on abuse reporting changes as a result of the passage of AB 40. On this webinar today, we have Lisa Coleman, the Executive Director of the California Long-Term Care Ombudsman Association, and Mark Reagan with Hooper, Lundy & Bookman and CAF General Counsel. This webinar today is targeted to mandated reporters working in long-term health care facilities. Most of you are coming from skilled nursing facilities, but there may be some other individuals representing other facility types who are on the call today. This call is meant to explain the changes in California's mandated reporting laws as a result of AB 40, and I just want to thank you for taking time out of your busy day to join us on this webinar this afternoon. I also wanted to thank the California Association of Health Facilities for partnering with us on this webinar and for helping get the word out to their members. I'd like to also thank Leading Age California for helping get the word out and publicizing this webinar to their members as well. We'll be taking questions at the end of the webinar this afternoon, and we ask that if you do have questions, if you can use the question box feature in the GoToMeeting panel. There's a space near the bottom of the box there where you can write in your questions, and we'll take those questions at the end of the webinar this afternoon. We will be recording the webinar, and we will make the recording available later for viewing at your leisure. So again, if we can move to the first slide here. Why has there been a change in California's mandated reporting law? Prior to the enactment of AB 40, as you know, elder and dependent adult abuse that occurred in long-term care facilities was reported to either the local long-term care ombudsman program or the local law enforcement agency. In most states, mandated reporters report suspected abuse or neglect to either local law enforcement, adult protective services, or the state licensing agency. In California, though, the legislature had given the responsibility of receiving and investigating reports of abuse that occur in long-term care facilities to the local long-term care ombudsman program as well as the local law enforcement agency. California is one of 6 states that has had that responsibility. As I said, in most other states, that responsibility is carried out by another entity, either adult protective services, local law enforcement, or the licensing agency. The Ombudsman program is established by the Federal Older Americans Act, and there are confidentiality requirements in the Older Americans Act that prohibit ombudsman representatives from disclosing the identity of residents that they're working with to anyone, including law enforcement, without the consent of the resident or the resident's legal representative. And so here in California, having that mandate to preserve and protect the identity of the resident placed the Ombudsman program in somewhat of a unique situation. We had to be able to protect the identity of the resident, but also investigate this report of suspected abuse or neglect. If we couldn't get the consent of the resident to disclose his or her identity, or the consent of the legal representative to disclose the identity of the resident, we could not cross-report that identity to local law enforcement. The only other way that we could provide the identity of the resident is by court order. Long-term care ombudsman program data showed that in fiscal year 2009-10, almost 3/4 of residents who may have been the subject of a report of elder abuse or neglect did not consent to disclose their identities. That created a problem in that law enforcement may not be able to investigate some criminal abuse cases that occur in long-term care facilities, leaving residents vulnerable. AB 40, and Mark will be going into the details of AB 40 momentarily. AB 40 attempted to rectify this problem by having mandated reporters report instances of suspected or known physical abuse first to local law enforcement and then by written report to the Ombudsman program and to the licensing agency. By doing this, local long-term care ombudsman programs no longer have to fear not being able to disclose the identity of residents because law enforcement will already have that information. In fact, law enforcement will have that information well before the local long-term care ombudsman program will. And more importantly, it gets into the hands of law enforcement known or suspected cases of physical abuse where serious bodily injury has occurred. At this point, I'll turn the presentation over to Mark, who will go through the changes with us this afternoon.
Thanks very much, Joe, and good afternoon, everyone. For those of you who have been around, certainly long-term care and skilled nursing, know that the issue of abuse reporting is an extremely complicated and in some instances fraught area of the law. And that's because there are really so many different requirements that that are present depending upon whether you are a mandated reporter, whether you're a facility, whether you're a combination of both. So let's start with the principle of what changes to what reporting systems are being made by Assembly Bill 40. Okay. First and foremost, these are changes to the individual mandated reporter statute, in that this is the Welfare and Institutions Code section 15630 that governs individual reporting. That is separate from the specific facility reporting responsibilities that for skilled nursing facilities under state law are present in Health and Safety Code section 1418.91 and under the OBRA regulations are present in 483.13. So first and foremost, understand that the changes that we're talking about here today are for the individual mandated reporter laws and do not, for state law purposes, alter facility reporting laws that are already on the books. So what's the additional wrinkle that comes into play here? The additional wrinkle was healthcare reform, and as part of healthcare reform, the Elder Justice Act and its abuse reporting provisions, which in the areas of who is a covered individual, as you may recall, basically includes an owner, an operator, an employee, a manager, agent, or even contractor of a long-term care facility. And you may also recall that under the Elder Justice Act, the responsibilities for reporting had to do with the reasonable suspicion of a crime, and then the time frames associated with those reports were the byproduct of whether there was serious bodily injury that came along with a reasonable suspicion of a crime, and then there was a 2-hour limit if there was serious bodily injury, and we'll talk a bit about what that means in a moment.
Mark,
and then yes.
I'm sorry, if you could give me control of the screen again. We've lost the slides, and then I'll bring the slides back up, but you still have audio.
Okay. I'm not really sure what to do to give you back control.
If you click on my name and make me the panelist.
So I'm trying to do that.
There should be a button right above my name that says who you can designate as a panelist.
Yeah. Does that help?
Yes. Thank you.
Okay. Well, since we're still on the first slide, we haven't really advanced very further in the program, and so where I was that we have changes that are reflected in Assembly Bill 40 that alter the individual mandated reporter laws. At the same time, we've had the existing facility reporting laws, and the additional wrinkle that's come into play in the most recent periods of time came from the Elder Justice Act and its reporting obligations for, again, everybody involved in the operation of a long-term care facility, and the time frames being delineated from the standpoint of whether there was serious bodily injury as defined, creating one set of time frames, and then any other lesser harms, if any harm at all, within a differing and longer period of time. So basically what this law tries to do, it tries to fix the underlying problem that Joe described in terms of confidentiality, but makes a first step to try to harmonize these disparate, different reporting requirements that impact all of your employees and yourselves as facilities. Next slide, please. So from the Ombudsman's perspective, the most important consideration that they're thinking about is whether this is abuse occurring in a long-term care facility, which if you look at the law is clearly going to include a skilled nursing facility, will include ICFDD facilities, ICFMR facilities, and all ICFDD facilities that fall underneath it, and then a number of other types of health and residential facilities. But here we're really talking about SNFs today. The second element, and one of the most important elements for this change in the law, is the notion about whether or not the suspicion that you have of what has occurred is a suspicion of physical abuse. And we'll talk about that particular definition in just a second. And then if you have a suspicion of physical abuse, then what are those time frames for reporting, and who must receive those reports under these revised mandated reporter laws? So let's talk about, first of all, what is reportable abuse, and then let's talk about what is physical abuse. Well, in the Welfare and Institutions Code, there are a number of different events or things that constitute or can constitute abuse. Those definitions are contained in 15610.07 of the Welfare and Institutions Code. One of those subsets is physical abuse. Other concepts within the definition of abuse not arising to physical abuse include things like abduction, isolation, neglect, but physical abuse is a very specific defined term under state law, and it is contained in Welfare and Institutions Code section 15610.63. And there are multiple parts of it, and really the way the law is structured in this area in California is that physical abuse is tied in the vast majority of instances to specific crimes. So for example, the first crime listed under that section of physical abuse is assault. Assault, if you look at the referenced penal code provision, is described as an unlawful attempt coupled with a present ability to commit a violent injury on the person of another. The second crime that is defined as physical abuse is battery, and that is the willful and unlawful use of force or violence upon the person of another. It goes on to describe other crimes defined specifically in the penal code, such as sexual assault, sexual battery, rape, incest, sodomy, oral copulation, lewd and lascivious acts, and then it has a provision specifically with respect to the use of physical and chemical restraints or the use of psychotropic medication that's either used for punishment for a period beyond a time frame for which that particular medication was ordered, or for any purpose not authorized by the physician and surgeon caring for the specific resident. You also defined as physical abuse as the unreasonable physical constraint or prolonged or continual deprivation of food or water. So you can really tell when you look at 15610.63 that physical abuse is, in most instances, it is something that involves a physical attack, or at least an imminent threat of a physical attack. The only things that were on that list that I just described that really don't fit that particular characterization are the issues of deprivation associated with food, hydration, and the like, or the use of physical or chemical restraints. I draw that line because when you think about physical abuse up against other types of the broader category of abuse, in most instances, anything that involves a physical attack or an imminent threat of an attack is going to be something that will be properly characterizable as physical abuse, and really that essentially reflects the key elements of these particular changes and really attempts to harmonize, at least as a first step, what state law in this area attempts to do and what Congress did in the Elder Justice Act. Because when you think about it, stepping back for the moment, California's mandate is to report suspected abuse, which can include physical abuse, can involve neglect, can involve any of the other things that are defined as abuse. And the Elder Justice Act speaks to the notion of the reasonable suspicion of a crime. All right. Well, since the clearest picture of the crimes in this area against elders largely arise, probably with the exception of financial abuse, in the areas of physical abuse, that seemed to be a place where the California legislature focused with respect to Assembly Bill 40. And what we'll find when we get there is that the underlying nomenclature, the trigger points, and some of the reporting timeframes are specifically aligned to what Congress did in the Elder Justice Act with respect to that abuse reporting. Next slide, please. Beyond some of the changes that are present in 15630B, which has been the mandated reporter section for long-term care employees and others operating in the skilled nursing and care of the developmentally disabled world, other than 15630B, which is what I would encourage you to go back and take a look at after you've had the chance to digest these materials, is an additional definition of what serious bodily injury involves. And again, as I said before, that's the bridge between this particular change of state law and what the Congress did with respect to the Elder Justice Act. This became effective January 1st of this year. And so in terms of looking at the number or the specific administrative agencies that need to have reports made of suspected physical abuse, that has changed effective essentially 9 days ago. Next slide. So, when you think about how your reporting and your employees' reporting responsibilities have changed here, you think of it from the standpoint, at least under state law. Physical abuse is what it is that we're observing or hearing about or suspecting is first physical abuse. In most instances, as I described, a physical attack or threatened physical attack from one person to another. Whether or not that has resulted in serious bodily injury. This is the language that's used in Assembly Bill 40. It is almost identical, not precisely identical. The only differences between what 15610.67 and what the definition in federal law is that you see at the third to last line the phrase "but not limited to." The only difference between this and what federal law says is federal law says "such as," which in my view does not really alter it. But if you were to line them up, that would be the only difference. So if you have a situation where that you suspect that there's been physical abuse and that it reasonably appears to the mandated reporter that there is extreme physical pain, a substantial risk of death, a protracted loss of impairment of function of a member, organ, or of mental faculty, or, and this is probably the most significant element of this, requiring medical intervention. When you think of all of the, when you think of the baseline here, when I look at this definition, if there is an injury that's going to require medical intervention that is, in most instances, going to be hospitalization or something that's more in depth than conceivably just a visit from the physician, though I'm not sure that I would even draw that line. That's really the baseline of what serious bodily injury is. Obviously, any mandated reporter within their own scope of practice and their own reasonable belief is going to make a determination about whether somebody is in extreme physical pain, whether they're going to require medical intervention, and then are they at risk of losing functionality, and are they at substantial risk of death. That's the trigger point that we'll see here for the time frames now that are going to govern mandated reporting under the Welfare and Institutions Code. Next section, please, or next slide, please. So, if a mandated reporter suspects physical abuse that has, in their view, resulted in serious bodily injury using the definitions that we just went through, or the definition we just went through, then basically what this comes down to is a baseline of a 2-hour time frame for a report to be made. Now you'll see that there's a reference to the SOC 341 on this slide, which probably most of you are very familiar with because that's the form that has historically been used with respect to these reports. And one of the things that I know that one of the goals of Assembly Bill 40 was to try to do was to standardize the SOC 341 to be able to be used not only for reporting that fulfills state law in this area, but also for reporting that fulfills the responsibilities that were enacted by Congress under the Elder Justice Act. So the change here, as you'll recall, is that there would be a choice in the past if there was suspected abuse under state law to report to either the local long-term care ombudsman's office or local law enforcement. Okay, you will see that state law for mandated reporters now has 3 locations for those reports to go to, and those include local law enforcement, the long-term care ombudsman's program, and and licensing. So there are 3 locations now for the individual mandated reporter to make this report when there's physical abuse resulting in serious bodily injury, and that report needs to be made within 2 hours of obtaining knowledge. Now, the intent of the law is for that report to be made as soon as possible, but the baseline element of it is 2 hours. And as we'll see, because there's an attempt to try to harmonize reporting across various different reporting requirements, what we'll find when we get to some of the subsequent slides is that the law is going to deem the fulfillment of this requirement to these 3 different sources to fulfill the obligation under the Elder Justice Act, and then also fulfill some of the facility reporting obligations that exist under state law. So those are the time frames with respect to physical abuse resulting in serious bodily injury. Next slide, please. Okay, so we just got done talking about a 2-hour time frame. And now what's the significance now of the definition and whether or not a mandated reporter reasonably believes that there's been serious bodily injury? Well, it all has to do with the timing. Here, looking at this slide, you'll see that who the report is made to does not change if the underlying suspicion of abuse is physical abuse. The only thing that changes is the time frame, whether or not the result of the suspected abuse in the reasonable belief of the mandated reporter is serious bodily injury or not. And here you see it is a 24-hour period of time. Again, the intention to use the SOC 341 as the sort of core document to be able to get to local law enforcement, the long-term care ombudsman's program, as well as the Department of Public Health, in this instance within 24 hours. Next slide, please. Here is a bit of a different wrinkle, and it's one that really recognizes, I think, to some extent for the first time, that we have situations that are, depending on what all of our facility patient populations look like, of resident-to-resident altercations. This particular provision of Assembly Bill 40 essentially says, look, if there's an instance where there is physical abuse suspected, and if you go back to where I began here, particularly in the areas of assault and battery, it can be difficult to oftentimes draw the line about exactly when you have a resident with dementia having an altercation with another resident, perhaps also with dementia or not, whether or not they have the ability to be able to essentially have the capacity to commit a crime. And that's one of the places I think that it's most difficult for all of us who are working in long-term care to figure out how to go about it. What Assembly Bill 40 does is that it says, look, if you have a situation where you have the alleged perpetrator of physical abuse having a history of and a diagnosis of dementia, then perhaps in this instance we're not going to have the need, particularly and only when there has not been serious bodily injury, what I think of as sort of the low-grade altercation situation, that you can report that under the individual mandated reporting laws to either local law enforcement or the long-term care ombudsman's program, rather than from an individual mandated reporter standpoint, reporting to all three. Now, I'm going to tell you, practically speaking, I don't know if it's possible to really sort of attempt to operationalize all of this, because when we get to thinking about the facility reporting laws, even in an instance where there's suspected physical abuse that has not resulted in serious bodily injury with the alleged perpetrator having dementia, you're still going to have a facility obligation to report to the Department of Public Health. So practically speaking, I don't know that this particular provision ends up being significant practically or operationally. But as I said, this is a first step. I think Assembly Bill 40 reflects that. I think that there has been some expressed desire to perhaps go and do some cleanup work on it. But here is sort of what I think of as sort of the first recognition that situations involving resident-to-resident altercations involving the perpetrator having dementia is being viewed somewhat differently than in the first two instances that we spoke about. Next slide, please. So this is a slide that sort of attempts to graphically depict from the long-term care ombudsman's perspective the ways in which these changes to the mandated reporter laws have essentially been changed. And this is something, again, recognize this is the state individual mandated reporter laws. These are reflective of essentially the changes that we've talked about, specifically tied to when there is knowledge of or a reasonable suspicion of physical abuse, as compared to other types of other types of abuse recognized under the law. And you'll see that graphically that it takes you through each one of those three examples. The first two being, look, we have suspicion of physical abuse, there's serious bodily injury, or there's no serious bodily injury, and you have all three reporting agencies receiving those reports, and the only difference between those two are time frames. And then you have the third instance where you have no serious bodily injury, as we just discussed, but you have a resident-to-resident altercation, and you have the alleged perpetrator having a diagnosis of dementia. Next slide, please. So I've just told you how things have changed for those particular nuanced elements of abuse reporting. And as we've talked about, some of that had to do with confidentiality, some of it had to do with at least a first step to try to harmonize the Elder Justice Act. If you have other forms of suspected abuse than physical abuse, then the existing mandated reporter requirements at the baseline are going to be the same, which is either choosing to report to local law enforcement or choosing to report to the local long-term care ombudsman, and then the baseline there in terms of a report, again, in SOC 341 within 2 working days. I raise all of this from the standpoint also to say, look, again, there's still a marked element of complexity here, and now we're making some additional complexity and drawing lines between timing and who gets reports, between physical abuse, depending upon the severity of the harm, versus other forms of abuse, and with differing time frames, and whether or not, as an individual mandated reporter, everybody's going to be able to sort out these nuances, I think remains to be seen. Certainly, the simplest way to go about this is to make reports to local law enforcement, the Ombudsman's Program, and the California Department of Public Health. If you do all those three as a mandated reporter, and you do them as soon as possible, and certainly not beyond the time frames that are set forth here, you're going to be safe. As to whether or not mandated reporters can navigate the nuance of this. I think from a practical perspective, I think you're probably best in the position to be able to figure that out. And it may be that some mandated reporters will be able to, and some may not be able to. But it's one thing to look at the law here, and it's another thing to look at, what's practical. But at the baseline, the change that's happening here is that we're looking at, in the most, what I would call serious cases of suspected abuse, for reports to go to law enforcement, the long-term care ombudsman, and to the Department of Public Health. Okay, next slide, please. So the 341, as I've said, is going to continue to be the controlling document. It's being revised. It's being revised to reflect the changes that are present in Assembly Bill 40. As we sit here today, we don't have a changed SOC 341. So I think you need to do the best you can under the circumstances, but this law, as I described, is in place today. So the time frames of the report, the locations to which the reports need to be made, need to be consistent with the law, but the form that you're used to and the SOC 341 will change. I don't think that it'll change greatly, but it will change. One last point also about that. 15630 of the Welfare and Institutions Code, the section we've been talking about, allows for the provision of a group report, and that is also the case, by the way, for the provisions of the Elder Justice Act. And so I suspect that some of the additional detail will also involve group reporting and the like. But know that there's going to be a new form of the SOC 341. I have no doubt that CAF will make it accessible to its members. But here's another way to get a hold of the new SOC 341 that we expect to be released towards the beginning of next month. And it'll be posted on the Long-Term Care Ombudsman's Program site, as well as continue to be available through the Department of Social Services. Next slide, please. And here's the SOC 341 as we know and love it today. I'm sure you can't read it any better than I can, but this is, if you haven't seen this form before, this is the SOC 341. And this is what currently the Department of Social Services is working on revising to meet the provisions of Assembly Bill 40. Next slide. All right, let's make a transition here, because the individual mandated reporter laws are really, as we've discussed, just part of your world. And we have these other reporting systems. The most prominent ones are the facility reporting systems. And you will note that, and I've excerpted the language directly out of it, and what really to know about this is the Health and Safety Code state law facility reporting requirement. You see that it has a 24-hour time frame. But now, having looked at the provisions of Assembly Bill 40, the individual mandated reporter in the instance of suspected physical abuse that has created at least the appearance of serious bodily injury is going to have a 2-hour baseline reporting obligation, whereas this law on the books that we're looking at now seems to create a 24-hour requirement. So one of the things that is part of Assembly Bill 40 is that if you follow the provisions of Assembly Bill 40 in the timing, with respect to the timing of your report, the 2-hour report that goes to the, among others, the Department of Public Health, then state law is going to deem you to be in compliance with the provisions of the Elder Justice Act from the facility's perspective. And so what was attempted to be done here was to try to draw a bridge between the facility reporting responsibility and the individual mandated reporter responsibility. So when you think about it from the standpoint of there being suspected physical abuse that results in what is reasonably believed to be serious bodily injury, if you make a report within that 2-hour time frame, that is going to work for your facility reporting obligation to the Department of Public Health as well. Next slide, please. Let me go back to the last slide for a second because I wanted to make one more point. What you'll find is that even in the instance where there is not serious bodily injury, if a report is made because of suspected physical abuse, even when there's not serious bodily injury, if the report is made within the 2-hour and 24-hour time frames done for Assembly Bill 40, then that likewise will, and that report is made to the Department of Public Health, that report likewise will suffice with respect to the facility's reporting obligation under state law. Okay, now next slide. As you all know, there's beyond abuse reporting, there is also the long-standing California Code of Regulation provisions involving unusual occurrences. And working with long-term care facilities over the years, oftentimes we have discussions about particular events and whether they would constitute unusual occurrences, whether or not they would constitute suspected abuse, or one or the other, or both. And so just as with the facility reporting obligations, also if the provisions of Assembly Bill 40 are met with respect to physical abuse, suspected physical abuse that either gives rise to serious bodily injury or no serious bodily injury, and the time frames addressed in there, the 2-hour time frame in the first instance or the 24-hour time frame in the second instance. If you fulfill those requirements, then the law will deem you to be compliant with the provisions of unusual occurrences as well. And this is something else that I expect, and we'll see when we see the revised draft of the SOC 341, whether there are boxes on there to deal with essentially the bridges that are being built between individual mandated reporting and facility reporting of both abuse as well as facility reporting of unusual occurrences. Next slide, please. Now, we all know, and as I said at the outset, there are other sources of facility reporting. The most prominent with respect to skilled nursing facilities from an OBRA regulation standpoint is the one that's on the slide in front of you with respect to alleged mistreatment, neglect, or abuse. Again, as you all are familiar, this is a report to the Department of Public Health, and these are the time frames essentially of that report. And then this is one of the places where Assembly Bill 40 didn't essentially deem compliance with the sort of shortened periods and the increased receivers of the report to be in compliance with this particular provision. That may or may not be the subject of any cleanup down the road, but just for the sake of completeness, this is the other skilled nursing facility reporting requirement out there that we have not yet spoken about. Next slide, please. And then last but not least, this is the equivalent ICFMR reporting requirement that comes out of the CFR provisions. And again, this is a place where there has not yet been a bridge built between, if there's a report that's in compliance with by the individual mandated reporter, whether that would be deemed to to meet the requirements of the Elder Justice Act or these particular provisions. So next slide, please. Before I turn it back over to Joe and folks from the Long-Term Care Ombudsman's program, I just want to back up and have you think a little bit now about how you'll want to structure your policies and procedures given this change. From the standpoint of wanting and expecting employees to bring instances of suspected abuse to your attention, nothing here changes that. Nothing in this that we've talked about changes any of the additional policies and procedures that you have that were put together with respect to compliance with the Elder Justice Act. The part of your specific policies that you want to think about is whether you address individual mandated reporting as part of those policies and procedures, and in terms of how you work with your staff and helping them understand and perform their obligations under the individual mandated reporting scheme, whether there's any element of either what you do with your policies and procedures that will need to change, as well as working with your own administrators, or in fact as an administrator, thinking about as an individual mandated reporter or as a director of nursing or any other employee of the facility, how you will manage this from an operational perspective. Because really at the end of the day, how this is changing is we're going from essentially always reporting to the Department of Public Health as the facility, and now we're moving to the place where instead of choosing between local law enforcement and the long-term care ombudsman, at least for physical abuse purposes, that now in a number of instances we're going to be making a report to all three of those organizations. So at the sort of bottom line takeaway here is as an individual mandated reporter, you've got three places to now make reports to, depending upon what event you suspect has taken place and how serious the harm is. And so I would encourage you to go back, take a look at your own policies, procedures, training, anything that you do with your staff along these lines, to make sure that they're consistent with these provisions. Joe?
Thank you, Mark. We're having a little technical trouble here. We need to turn off the mic. Thank you for that. Thank you, Mark. This is Lisa Coleman. I'm the Executive Director with CalCOA, and I get to talk about the cross-reporting aspect of AB 40. But a little bit about, the Ombudsman program. We are a federally mandated program. We are a part of the Older Americans Act. There are 35 long-term care ombudsman programs throughout the state of California. And currently, we have just under 1,000 field ombudsmen. I like to point out to facilities that while the field ombudsmen are trained locally, that training comes from the certification from the state. These ombudsmen are following a legal mandate that comes from the state ombudsman's office. So when your local ombudsman is in your community and they're monitoring and they're pointing things out, that shouldn't be from a perspective of opinions or their own personal objections or suppositions. This comes from the state training and the role of the long-term care ombudsman in your facility. Primarily, the ombudsman program has three mandates: to investigate, to resolve, and to educate. It's that third mandate, to educate, which makes me so excited that CalCOA, along with the state ombudsman and Mark with the California Association of Healthcare Facilities, has come together with this webinar. The whole point was to help educate facilities on the changes in the mandating requirements due to the passage of AB 40. I'm hopeful that the flow chart that you saw a few pages back will be helpful to you. The local long-term care ombudsmen have received 11,000 copies of this in a hard card format, and they will be disseminating it through all of the facilities over the course of their monitorings in January and February. And as facilities, you are also able to download and create your own copies of this flow chart. I think it's a helpful tool. It's got spaces available so that you can put in your own local phone numbers and fax numbers so that it will help to minimize the confusion that some of our mandated reporters might experience due to the changes. Now the slide talks about cross-reporting, and I want to point out that this is now a requirement. It's not that your local long-term care ombudsman is tattling or trying to rat you out by calling the cops. It is a part of the mandate that we are to cross-report as soon as practical. And when we're cross-reporting, I think it's important to point out, as an ombudsman, I would not be comfortable with saying to a police officer, I don't think you should investigate this. I think that's beyond my scope, beyond my ability. But as an ombudsman, it is within my mandate, and it is important that I cross-report my investigations, my findings, and my suggestions for resolutions. Again, it's not that I'm telling them not to investigate. I'm telling them what we've found out as ombudsman. So, next slide. Thank you for that. The ombudsman's the local programs are working with the law enforcement agencies in their cities and counties to create more effective cross-reporting methods. And I know that Joe, our state ombudsman, is going to be talking about that. I just want to talk one little bit about the cross-reporting element when we have alleged cases of physical abuse, especially when we're talking about a senior that has a diagnosis of dementia or dementia symptoms. In many cases, it's going to be the ombudsman working with the facility that's going to be able to resolve the complaint in the most immediate and appropriate response. I think many ombudsmen enjoy working facilities, creating care plans, working with training programs with staff and families, and many of the myriad of options that ombudsmen and facilities have when it comes to resolving issues, especially when we have seniors that have dementia symptoms. I don't think any ombudsman is really actively wanting to have law enforcement coming through our facilities, especially uniformed police officers, disturbing the residents and alarming many of them that have dementia. So we're hopeful that this cross-reporting will be viewed as a way to help resolve quickly and effectively, because the ombudsman goal is really investigate, resolve, educate. So I'm going to pass this back to Joe.
Thank you, Lisa. Again, as Lisa indicated, the Ombudsman's role here, as evidenced in the Welfare and Institutions Code, is to acknowledge that Ombudsman responsibility in abuse cases is to receive reports, determine the validity of these reports, and refer verified abuse cases to the appropriate agencies for further action. Other Ombudsman services will be provided to the resident as appropriate. Additionally, and again, this wasn't changed by AB 40 either, any victim of elder or dependent adult abuse may refuse or withdraw consent at any time to an investigation or the provision of protective services by APS or by the long-term care Ombudsman program. And as I mentioned at the beginning of the presentation, the whole reason for AB 40, a local long-term care ombudsman shall act only with the consent of the victim and shall disclose confidential information only after consent to disclosure is given by the victim or pursuant to court order, and that's consistent with our federal Older Americans Act requirements. At this time, we've only got about 6 or 7 minutes left for this webinar, but we will take questions that have been submitted to us from the question chat box. Let me review those now. There was a question about whether this change in the law applies to other senior care environments. beyond skilled nursing. It does apply to the list of long-term healthcare facilities that are licensed by the California Department of Public Health. So those would be the Adult Day Health Centers or CBAS programs, congregate living health facilities, the ICFs, and the three varieties of ICFs, nursing facilities, skilled nursing facilities, and also to community care facilities licensed by the Department of Social Services, residential care facilities for the elderly, adult residential facilities, and adult day programs.
And then, Joe, do you want to mention that I think that you all are going to be doing a program focused on those providers as well?
Yes. Actually, yesterday we had a webinar with the California Assisted Living Association that was targeted to mandated reporters working in residential care facilities. There was also another question about law enforcement, and has law enforcement been informed about these changes in the law, or will skilled nursing facilities end up having to educate local law enforcement about this? We were very sensitive to wanting to bring on law enforcement sooner rather than later, and so AB 40 actually strongly encourages coordination between local long-term care ombudsman programs and local law enforcement agencies. To that end, we've developed here at the state office a boilerplate letter and a model memorandum of understanding that local ombudsman programs can enter into with local law enforcement jurisdictions. We wanted to make sure that the most appropriate agency was responding to the report of suspected abuse or neglect. You know, as has been suggested earlier, if there are reports of physical abuse that have caused serious bodily injury, you know, we certainly want those reports to be investigated by local law enforcement. But if there's a situation where a resident with a physician's diagnosis of dementia is acting out and injures another resident or strikes out at another resident, that may not be an intentional form of abuse of another resident. It may be a behavior that's being manifested as a symptom of this person's disease process, and it may be a care plan issue that is better addressed by the ombudsman program in the facility rather than law enforcement. And so we'll be doing a webinar actually next week with local law enforcement to discuss the type of coordination that's going to need to occur between our program and local law enforcement. Let's see, another question. I think those are the questions I have. Annie, do you have any other questions for us? Yes, please.
Did the requirements change for the other types of abuse? Is this only for physical abuse?
Yes, the question was, did AB 40 affect reporting of other types of abuse, or was it just physical abuse? And it is just physical abuse. If there is verbal abuse or financial abuse or emotional or mental abuse, those instances, for those instances of suspected abuse or neglect, you have the mandated reporters still have the option of reporting to either local law enforcement or the local long-term care ombudsman program. So that has not changed.
Somebody piggybacked on that. What about resident-to-resident altercation?
There was a subsequent question about resident-to-resident altercations. If those altercations resulted in serious bodily injury or physical abuse but not serious bodily injury, those would fall under the provisions of AB 40 and should be reported to local law enforcement using the reporting methodology that we showed earlier in that mandated reporter flowchart, the one that's on the screen now. And again, this flowchart was mailed out yesterday or emailed out yesterday to all registered participants for this webinar. Your local long-term care ombudsman programs will have them. If you need additional copies, you can obtain them from them. and feel free, if you have the PDF version of this, to make copies and share them as well. We have time for one more question.
Did an EGA also include sexual abuse as serious bodily injury, even if not resulting in the severity of injury described?
The question was, did the Elder Justice Act also include sexual abuse as physical abuse? I believe it did. Mark, is that your recollection as well?
The way that Congress structured the Elder Justice Act was that when it used the term crime, it deferred to each local and state jurisdiction for what constitutes a crime. So in the question that was asked, because the kind of conduct that was discussed would be a crime under California law, it would be a crime for the purposes of the Elder Justice Act.
Thank you, Mark. Okay, it's now 3 o'clock, and I believe we've run out of time, and we've also run out of questions. I wanted to thank you for joining us today, and again thank our presenters, Mark Reagan from CAF and Lisa Coleman from the California Long-Term Care Ombudsman Association. Should you have further questions about AB 40 and your responsibilities under this new law, please don't hesitate to contact either CAF, your local Long-Term Care Ombudsman program, or us here at the state office. You can feel free to call our crisis line, 1-800-231-4024. That number is on the poster in all of your facilities, and we'll be happy to answer any subsequent questions that you have. Again, thank you for joining us today, and have a good rest of the afternoon.
Thanks, everybody.
Thank you.